Hello, this is David Rand from the organization Atheist Freethinkers in Montreal, and I'm going to be talking about understanding the Quebec Superior Court decision about Bill 21. The decision by Justice Marc-André Blanchard, which was rendered on the 20th of April of this year. I'm going to tell you what I think you need to know. Number one, the court decision reveals very clearly that the judge hates Bill 21, he hates secularism, and he does everything in his power to repeal Bill 21, but is limited in the damage he can do because the law's authors had the wisdom to invoke special charter clauses which limit the power of judges. Number two, what is Bill 21? In case you've forgotten, it's a very moderate and modest secularism law which bans some civil servants, including teachers, from wearing religious symbols while on the job, just as the Quebec Public Service Act bans them from making partisan political displays. In fact, Bill 21 is much weaker than the Public Service Act, and also weaker than similar laws in some European countries. Bill 21 also defines secularism, adds that principle to the Quebec Charter, and it bans face coverings when giving or receiving civil services. Number three, speaking of charter, there are two charters that are relevant here. There's the Quebec Charter of Human Rights and Freedoms, which was adopted in June of 1975 and has been effective since 1976, and it takes precedence over all other Quebec legislation. And it has a clause 52, section 52, which allows a law to take precedence over certain sections of the charter if the law states explicitly that it does so. Then there's also the Canadian Charter of Rights and Freedoms, part of the Canadian Constitution of 1982, so adopted several years later. It's been endorsed by 9 out of 10 provinces, but never signed by Quebec. And it too has a so-called notwithstanding clause. That is, Section 33 is a clause which allows legislatures to override temporarily for 5 years certain portions of the Charter, and whose insertion in the Charter was negotiated by some provinces, in particular Saskatchewan, in order to protect parliamentary sovereignty. Except for the use of Section 33, the Canadian Charter is supreme in Canada. So, to summarize, we're dealing here with a power balance between the legislative branch and the judicial branch. The authors of both charters have attempted to reach some sort of equilibrium between the two. Number four, Quebec Bill 21 invokes the so-called notwithstanding clauses of aspects of both the Quebec Charter and the Canadian Charter in order to protect the legislation from being struck down by the courts. Number five, the court decision rendered in April of 2021 validates most of Bill 21 for the simple reason that the judge had no choice because that law invokes the notwithstanding clause of the two charters. However, he does use two loopholes, Section 3 and 23 of the Canadian Charter, to which the notwithstanding clause does not apply, in order to do as much damage as he can to Bill 21. Okay, number six. Section 3 of the Canadian Charter guarantees the right to vote and to be eligible to serve as a member of a legislature. The judge used this to strike down the part of Bill 21 which bans sitting MNAs, members of the National Assembly in Quebec City, from wearing face coverings. Just to be clear, Bill 21 does not ban sitting MNAs from wearing religious symbols, only the Speaker and Vice Speaker of that Assembly. It bans face coverings for MNAs. So, since the judge struck this down, this means that MNAs may now participate in the Assembly wearing a kneecap. Number seven. Section 23 of the Canadian Charter deals with English and French minority language rights. The judge used it to strike down the application of Bill 21 to English language schools. This amounts to discrimination against English-speaking children, depriving them of the protection which Bill 21 affords them. The implications of this exemption are a partitioning of Quebec along linguistic lines with different rules for different language groups, rules which have nothing to do with language. After all, we're dealing with a secularism law here. It has nothing to do with language, whether you speak English or French. Does this mean that French language school boards in English Canada can now ban their teachers from wearing religious symbols? If we're going to allow an exception for the English schools in Quebec, we've got to allow an exception for French language schools outside Quebec. Point number 8. In both cases, the right to elected office and minority language rights, the judge, Blanchard, is using an extremely exaggerated interpretation of the corresponding right. In fact, his interpretation is absurd. In what universe does banning teachers from wearing religious symbols in the classroom discriminate on the basis of language? In what universe can one possibly justify allowing an elected member of a legislature to hide their face while participating in that assembly? How on earth could banning the face covering interfere with that person's right to run for public office? Point number 9. The judgment rejects out of hand laws in several European countries which are similar and sometimes much more extensive than Bill 21. Point number 10. The judgment rejects Quebec's specificity within Canada, but it asserts Anglophone specificity within Quebec, as we have just seen. Hence the exemption for English language schools. The inconsistency here, or rather hypocrisy, is blatant. Point number 11. The judgment rejects out of hand any comparison between political and religious symbols. The judge does this by claiming that banning religious symbols, unlike political symbols, violates the soul or essence of the religious believer. The judgment reads as if it were written by a theologian, even criticizing Bill 21 for ignoring the law of gods. Elle ne peut en faire abstraction, he writes. So, is the judge so naive as to think that such laws of God were written by someone other than human beings? His thinking is medieval. Point number 12. The judgment essentializes religious affiliation as if it were innate and immutable, like a racial identity. This essentialization implies the complete negation of freedom of conscience, as if each person must remain prisoner of the religious tradition into which he or she had the dubious luck to be born. Religion as destiny. Point number 13. The judgment privileges religions by granting freedom of religion a higher priority than several other freedoms, higher than freedom from religion, while these two freedoms should have equal importance. It grants freedom of religion a higher priority than freedom of conscience, which in reality includes the other two as subsets. It grants freedom of religion a higher priority than freedom of political opinion, as we've just seen, by using the excuse of the soul or essence to claim that religious symbols are way more important than political symbols. In reality, a religious symbol is a political symbol, especially when it's worn by a civil servant in a position of authority. Point number 14. The judgment participates in the hysterical campaign of hatred against secularism and against Québécois who support Bill 21 by a large majority by referring to them with expressions such as tyranny of the majority. This anti-Québécois prejudice has been a major theme throughout Canadian history. Point number 15. The organization with which I work, Atheist Freethinkers, intervened in the court case, arguing for Bill 21. The judgment sums up our intervention, but does not take it into account, and the same can be said for the other two associations which intervened in favor of the legislation, the MLQ, the Mouvement Laïque Québécois, and PDFQ, pour les droits des femmes du Québec, a feminist organization. Arguments for Bill 21 are simply not taken into account. The judge's argumentation and conclusions are based almost entirely on the arguments presented by the opponents of secularism. In particular, point 16, the judgment overwhelmingly emphasizes the freedom of religion of teachers and civil servants while completely ignoring the freedom of conscience of school students and civil service users. Thus, the judgment places freedom of religion above all other freedoms, and in particular above freedom from religion, as I mentioned above in point number 13. Point number 17. one small piece of good news. The judge rejects the specious argument that Bill 21 violates sexual equality guaranteed by Article 28 of the Canadian Charter. However, the argument used is highly technical and does not affirm the most important point. That is, it is religion whose influence in the state Bill 21 is attempting to limit, which is the cause of sexism and misogyny. Bill 21 helps to protect sexual equality, and it is absurd to assert the opposite. Excuse me. And finally, my final point, number 18, the appeal. The Quebec government immediately announced its intention to appeal the judgment, as, in the government's opinion, it creates two Quebecs by exempting English language schools. Several opponents of the bill, the National Council of Canadian Muslims, the Canadian Civil Liberties Association, and the FAE, the Fédération Autonome de l'Enseignement, a union, have indicated that they too will appeal in an attempt to strike down Bill 21 entirely. The FAE is a teachers' union which has not consulted its members on this issue since 2012, when 77% of 1,955 teachers polled agreed that state representatives should not wear visible religious symbols. In other words, the union leadership is pursuing an ideological goal and is disconnected from its own membership. So that gives you a good overview of what happened in that decision by Quebec Superior Court, the decision by Judge Blanchard, which he rendered on the 20th of April of this year, 2021. Thank you for listening.